Hello and welcome to the State of Michigan's ADA 30th Anniversary Series. Today we are featuring Michigan's Elder Abuse Taskforce and talking about how that impacts people with disabilities.
Hello, and thank you, Kelly. We're delighted to be a part of this ADA 30, and the videos that we see on your website are absolutely outstanding. So thank you for inviting us. I'll start out with some questions for Scott Teeter, who is the Attorney General's lead on the Elder Abuse Task Force. Scott, can you tell us why the AG's office set up the Elder Abuse Task Force?
Three things happened all at the same time. During her campaign, Attorney General Nessel traveled all around the state and kept hearing over and over and over very similar stories about people that were very frustrated with the guardian system in Michigan and then other issues related to our elder and vulnerable populations. And so she had in her mind coming into office that she wanted to do something during her tenure about that issue. And at the same time, she reached out to Chief Justice Bridget McCormick from the Michigan Supreme Court, and they discussed that same topic of what could the court do in playing maybe a more active role than they would traditionally perform in assisting in addressing some of the shortfalls in the system. At the same time, I had drafted a memo designing an elder abuse task force to be run by the Michigan Office of Attorney General. And so when we put that all together, the Supreme Court agreed to basically co-chair the task force with the Office of Attorney General in a really unique partnership to be able to then address really a myriad of issues across the state dealing with older or vulnerable adults.
Well, it sounds like it was really meant to be. What is the Elder Abuse Task Force?
Well, it was formed in March a year and a half ago. And during that time, we actually put together over 50 organizations with over 100 people, almost 20 just from the Office of Attorney General, to sit on this task force. The task force meets once a month to review all of the progress of all of the different committees and the subcommittees. And usually at that meeting is the Attorney General herself and our legislative liaison, and then also at least one and sometimes two members of the Michigan Supreme Court, Justice Kavanaugh and Justice Bernstein. In between those meetings, there every 2 weeks are a full day of committee meetings. There's 9 committees, and then in addition to that, there's multiple subcommittees under those committees that meet virtually every week.
Sounds like a lot of work. I remember when it started, you told everybody to send their worker bees. And I think that's really true. So can you expand a little bit on who's involved? You mentioned over 100 entities. So who are some of the folks involved?
Sure. Well, obviously we have the Office of Attorney General, and we have several divisions that are involved in it because we have a number of different divisions that have contact with elder vulnerable populations. Obviously, my division, which is financial crimes, many of which victimize elder adults or vulnerable adults. Your division with public administration, and you've been involved in the task force from day one. Our HEFS division, which is Health Education and Family Services, that works with adult protective services. Our healthcare fraud division that deals with nursing homes. But then outside of our office, the Michigan Supreme Court has 2 sitting justices who are on the task force. As I mentioned, Justice Kavanaugh and Justice Bernstein, and they played an active role in the task force. Early on when we did the listening tour, they were an integral part of that. The State Court Administrator's Office, Adult Protective Services, the Michigan State Police, the Prosecutors Association, the Sheriff's Association, the Michigan Association of Chiefs of Police, Area Agency on Aging, and Annie Uraski, who's the director of the Division on Deaf, Blind, and Hard of Hearing for the Michigan Office of Civil Rights. Also Michelle Roberts from Disability Rights. We have Legal Aid. We have Michigan Elder Justice Initiative, Elder Law of Michigan. We have legislators on there from both parties and from both chambers. The governor has sent the lieutenant governor as her representative. But really, it's the broadest based task force I've ever seen. And I believe the broadest based task force that the Attorney General's office has ever had. To get the full listing, you can go on to the elder page of the Michigan Office of Attorney General website and see all of the organizations that are on there. Area Agency on Aging I mentioned, but AARP is on there. The Long-Term Care Ombudsman, the Poverty Law Program. I mean, private attorneys that work in the probate section of the bar, the elder law section of the bar. We had, not only do we not have one group that turned us down, but we had many, many entity groups contact us once the task force was up and running, seeing how they could play a part.
Wow, that is an impressive list. And you mentioned that the information is on the Attorney General's Elder Abuse homepage. I just want to highlight for our listeners, that's at mi.gov/elder abuse. And on there, Scott mentioned many of the participants, but there's a list of participants on there, as are other information that I think is helpful. So Scott, tell me, what are the main goals of the task force?
When I first designed the task force, I went back and took a look at two prior task forces that had been organized in Michigan dealing with different issues as it related to elder or vulnerable adults. One of them was in 1999. It was organized by the Michigan Supreme Court, and it was on guardianships and conservatorships. And they made a series of recommendations to the system that they put together in a report, many of which were not implemented. Some were in changes to the legislation that eventually became the Emancipated Protected Individuals Code, which is the probate court statutory structure. But then in 2007, Governor Granholm had a task force on elder abuse, and they made a number of recommendations as well, many of which, because it was at the end of her term, never got implemented. So rather than just put together another report, when I sat down with the Attorney General, I asked her, do you want to generate another report? Because frankly, we have all the information we need. All we have to do is go back and check, are these problems still present? And the answer was yes. Many of them had gotten worse. But so it's not a matter of studying to identify what the issues are. We know what the issues are. The question is, can we take those things that they identified as solutions to some of those problems and begin implementing them instead of just having another year-long discussion about the problem? And her position was, I don't want to generate a report. I want to generate change. And so that's really what the last year and a half has been, and where the task force is going. We pulled the first 9 initiatives out of those 2 early reports, and then made a couple of our own. And that was going to be the first 9 things that we would tackle. And then we would, at that point, as we move forward with those, begin to identify other issues and start working on those as well. So when I identified those, we broke the task force up into different committees to really address several of those different areas, and then even subcommittees below that, because some of them are very complex issues. So those 9 initiatives, I think we have a slide on that. One of the issues that was a grave concern to us was the guardians, professional guardians, and requiring guardian certification. One of the stories the Attorney General tells repeatedly is that in the state of Michigan, you have to have a license to cut somebody's hair. You have to have a license to sell a Christmas tree, but you don't have to have any formal license or certification to be appointed by a judge to take over another human being's finances or another human being's life and exercise the authority of a guardian. We believe that's wrong. And so what we've done is draft legislation that would mandate certification by guardians if you're going to be a guardian over 3 other individuals. And you would have to go through the training with the National Guardian Association and the background check and the bonding, all of those things, the continuing education that would help raise the standard that guardians would be able to maintain and would have to maintain if they were going to take control over another human being's life. In addition to that, one of the frustrations that we heard regularly was that guardians were being appointed to actually also take control over somebody else's finances, which is really the role of a conservator, and I'll explain those in a minute. But they were exercising authority over the money, but there was no requirement for a guardian to have to file a report outlining how the money was spent. out of a particular individual's resources. So family members would often be very frustrated by the fact that the guardian didn't answer to them, didn't provide them any information about where their mom's money was going. So one of our recommendations was to require, if you exercise the role of a conservator, even if you're only appointed as a guardian, that if you were controlling somebody else's money, you had to file the same reports. So you had to file the initial inventory and then a report every year that the court would actually review to determine if there's any improprieties in the conduct of that guardian in control of somebody else's money. We also, our third one was to adopt a standard investigation form. Back in 1994, the state mandated a standard investigation form for domestic violence cases, and that every police department throughout the state would use the same form because those cases tend to break down in very similar ways. Well, we have the same thing with elder abuse. There's a pattern to that behavior. And in fact, a lot of the dynamics in elder abuse mimic those in domestic violence. So we created a standard investigation form. The head of the Prosecutors Association, the chiefs of police, the Sheriff's Association, and the state police all joined with my boss a year ago in September at a press conference, and formally adopted that form as the best practices document for investigating elder abuse, neglect, or financial exploitation. It was then distributed to every police officer in the state. And then we followed that up with a series of trainings that are ongoing, but posted on a law enforcement access only website so that they can review regularly training on how to complete that form appropriately and furnish it to prosecutors. So in addition to that, there were a couple other things that just seem very basic, but the law in Michigan doesn't, we believe, protect individuals under a guardianship. And that is that there are certain due process requirements if you're petitioned, someone files a petition to have a guardian appointed to take control over your life. And these petitions were filed on an emergency basis, which would bypass all of the due process protections. So you wouldn't have an attorney, it wouldn't require medical testimony. And really it was created originally as an exception that would be only used in really dire circumstances, like you needed the life-sustaining treatment and there was nobody else to provide permission to get the treatment. That's not what happened. And the exception sort of swallowed the rule. And all of a sudden people were being appointed guardians without any notice, without any representation, without a medical review. And we needed to change that. So we've drafted legislation to clarify what really is an emergency under Michigan law and what's not. And we believe that will further protect the rights of the alleged incapacitated individual. In addition to that, especially when we went on a listening tour, one of the major complaints was visitation. And that was that under Michigan law, a guardian has the authority to cut off visitation of anybody with the person who's under their care, the ward. So that means if for some reason you had a falling out with your brother and your brother's the guardian, or with a professional guardian, with a phone call to the nursing home, they could cut off your visitation to your mom, and there's no review of that decision at all. That is absolutely reprehensible. And so we decided that we actually have a bill that's moved through committee right now, but it created at least the opportunity to challenge those decisions in court and have the judge make the decision. And the basis for that would be, for some reason, you represent a threat, either emotionally or physically or financially, to the person they're trying to cut off visitation. And the guardian would have to be able to establish to the court's satisfaction by a very high standard why you represent a threat to visiting your mom when you've been visiting her for 50 years. So, but that was one of the major complaints, is that if they called the professional guardian too many times and they got angry, they cut off their visitation. Or if, like I said, a family member and I had a falling out, they'd cut off the visitation, and they were using visitation as a weapon. And that's not appropriate. And we need to rein that back in and really put that authority back with court. In addition to that, one of the major and we believe most traumatic decisions ever with a vulnerable adult is the removal of that person from their home. And again, trying to create some protections for that person so that it's not just the guardian's decision to pull you out of your home and drop you into a nursing home. That decision would have to go back before the court, and the judge would have to make that decision based on the evidence before them that there really is no other less traumatic measure to be taken by the guardian to protect that individual other than removing them from their home. So we can't do in-home health care, we can't do visiting nurses, we can't do Meals on Wheels. All of that stuff has failed. Now we have no alternative. And that's simply not been the case. Many times that decision's made early on, and sometimes it can be for the convenience of the guardian. And it's easier to manage somebody who's in a nursing home than it is to line up all of the support services that would be necessary to provide care for that person in their own home. One of the other issues that we looked at was the number of wards per guardian. And there, right now under Michigan law, there's no limit. And so there are 6 individuals in the state of Michigan that have over 500 wards. It goes 500 all the way up to close to 1,000. Our position is that is too many to manage effectively. I tell people often I grew up in a town with 1,100 people. So that would be basically like putting me in charge of every single person in my town and have me responsible for every day-to-day decision for their care all at the same time. That's not possible. And so this one, we've sort of morphed it because it's a much more complex issue than it looks like. And the reason I say that is because there's issues of public funding, there's issues of fee schedules if you have private resources to pay for a guardian, and about half the caseload, there's no money to pay for the guardian at all. So it's not as simple as just setting a number. We have to figure out a way to address the other issues, and we have a committee working on that. One of our other major pushes has been to create mandatory reporting for financial institutions when they suspect fraud or exploitation of a vulnerable or elder adult. That's not required in Michigan. And as a result of that, oftentimes if somebody starts to victimize a vulnerable adult, they do it repeatedly. And we find out only after all the money's gone. And so we have to be able to be notified sooner than that so that we have the opportunity to stop the crime while it's being committed. It's sort of like by design, law enforcement's reactive. So a crime happens, you pick up the phone, you call 911, the police come, and we go from there. But if you knew that somebody was going to break into exactly the same house 3 nights in a row, you absolutely knew that for sure. Couldn't stop the first one, but we should be able to stop the next 2. That's exactly what happens with financial exploitation with vulnerable adults, is they pull money out the first time, they're going to come back and pull more money out after that. But if we're notified and we're involved in that process, we could shut that down and stop the next kind of crime from occurring. In addition to that, one of the issues has been to develop multidisciplinary teams. One of the positive things that came out of the listening tour, where the Attorney General and the Supreme Court justices toured the state, we did 12 stops, 2,500 miles, allowing people to come and share their experiences with probate court. And sadly, the vast majority of those were negative, but there were a couple positive ones. And we noticed the connection was where there was an active multidisciplinary team, the response from people in those communities tended to be more positive, because many of the people involved in the system were already talking to each other, addressing some of the problems in their particular county. And that's what I did in my county back in 1997. I had started my own multidisciplinary team. We were the second one in the state. And we were already examining those issues of how could law enforcement respond better? How could the banks work with us? How could estate planning attorneys, how could we work with Area Agency on Aging and Adult Protective Services? Well, we're developing a standard protocol for establishing those teams all across the state. But the team will look very different in Marquette, from Wayne County, from Berrien County to Berry County. But at least it creates a structure to say, how do we get people talking to each other in your community, drawing the resources that you have to provide more safety and security for the vulnerable adults in your community?
Wow, that's an impressive list. Not many task force start out with, here are things we're going to do. So thank you for sharing that list. And that list, in case anybody wants to review that, is also available at mi.gov/elder abuse. And Scott, you mentioned the investigative form. I know that's on the website too.
That's correct.
So what do people with disabilities need to know about this task force?
Well, I think the most important part is that they are actually very well represented on the task force. And as I mentioned, Annie Rasky has been a critical member of the task force from day one. She is absolutely terrific. She has such a sweet spirit and so tuned into these issues and how to raise the awareness with other groups who really may not even realize that there's some things that we're doing or not doing that are really affecting her community. And as a result of that, it's really helped our entire group to step back and go, okay, initially she would be the only one who'd have to step up and go, okay, but what about, and I see even more now in different committee meetings and all of that of going, okay, yeah, but what about, and we didn't ask those questions initially, and that's been very, very helpful. I mentioned Michelle Roberts from Disability Rights, because again, we use the term Elder Abuse Task Force, but the reforms that we're talking about don't just deal with elder adults. The definition in Michigan is actually vulnerable adult. We don't have an elder abuse statute. And so that can be anybody over the age of 18. And so as these issues play out, it will very well affect people in the disability community, even though they may be 30, 40, 50 years old. It's really about your capabilities and the vulnerability that you may have depending on either mental health issues or physical issues or disease process or a whole host of other things. And as a result of that, we believe that the changes that we're making are going to impact everybody, not just elder adults, in a way that's going to be really positive.
Yeah, boy, I have to reiterate that with Michelle's group and Annie's group. I know they've referred things to us and we followed up, and at least in one case, something's on appeal because of their direct line.
Mhm.
So I couldn't agree with you more. Let's back up a little bit. We've been throwing around the terms guardian and conservator a lot. Let's talk about that. What is a guardian and what's a conservator?
Good question. First of all, there's two areas under Michigan law where the court has the authority to appoint somebody else to take over an aspect of your life. And it's activated by someone filing a petition with probate court alleging that you lack the ability because of age, because of disease, because of mental health issues, because of chronic intoxication. It can be a whole host of things that impact your ability to provide care for yourself or to make decisions for yourself and to understand the nature of those decisions. So the court breaks it down in two ways. When you're talking about the physical care of an individual, where they're going to live, how they're going to get medical treatment, what type of environment they're going to live in, who's going to feed them, who's going to take care of their physical needs, that's a guardian. If you're talking about finances, then that's a conservator. And so with a conservator, you have the authority to collect the money if they're receiving some type of SSD or SSI or a pension, or we've had cases where it involves someone with a closed head injury. They're receiving a settlement or insurance payments or things like that. They would have the authority to collect that money and then pay for the care that someone else is receiving. And so the court can appoint one or the other or both, depending on the needs of that particular individual. And there's a level of accountability for each. If you are appointed as a guardian, you have to file an annual report. If you're appointed as a conservator, you have to file an initial inventory and then an annual report. And so what we're hoping is in some small counties, particularly, we see those lines get kind of blurred where they appoint somebody as a guardian, but give them control over the money. Well, then they should have the same accountability that somebody who's appointed as a conservator. And so you would have to file the same documents. So that's one of the law changes that we're pursuing.
How do guardian, if we only had a nickel for every time in one of these Zoom things, somebody told you to take yourself off of mute, we could all retire, right? So how do the guardianships or conservatorships come about?
Well, it's because someone, could be a family member, could be adult protective services, could be a mental health provider. Someone identifies that they believe someone else lacks the ability to provide care for themselves. And they file a petition with the probate court. It's set for a hearing. That person is appointed representation. And generally, particularly if it's a situation where there's a physical or mental disability that's alleged, then they would be ordered to undergo a medical examination. And that information would end up coming back to the court. There would be a guardian ad litem appointed by the court, which basically would be, and many times it's an attorney, although it's not required, and they would do an investigation. They would talk to family members, they'd talk to the person who filed the petition, they'd talk to the person's medical providers, and then try to determine, is that true? Does this person lack the ability to make their own decisions and provide for their own care?
So is it a court that actually makes the decision of whether a guardian or a conservator is appointed?
That's correct. Ultimately, once the petition's filed and the probate court, particularly in every single county, has that jurisdiction to have the hearing, listen to all the evidence, and then make a decision. Sometimes it's a situation where the person who's alleged to be legally incapacitated doesn't contest the petition, that there is a recognition that they do need that kind of help and they can't provide for themselves, and so they don't contest the hearing and the court orders it. But sometimes you have a right, if you contest it, to have an attorney appointed and take it to a trial.
So who usually files the petition, or who can file the petition?
Any interested party. So that could be a law enforcement officer, usually not, but usually it's adult protective services or a family member. Could be a medical provider, could be a community health professional. Any one of those folks would have the authority. Any person who has an interest in the care of that individual would have the authority to swear out the petition.
Interesting. What are alternatives for people with disabilities if they don't want to have a guardian or a conservator?
That's a really good question. And it's one of those things where planning ahead of time will help you to identify what your desires are. And the court generally will defer to those. And what I mean by that is, if you don't do anything, then when somebody petitions you in, the court's going to make the decision based on the best information that they have available. And that may not be what your preference is. So there are mechanisms under Michigan law, specifically powers of attorney, where you would execute documents while you're mentally capable of doing that, where you identify what the needs are that you believe you may have in the future and who you want to serve on your behalf to make those decisions for you. Because again, if you don't do that, the court's going to make that decision and may very well not be the person that you want to pick. So there's two different powers of attorney. One is specifically for financial affairs. And that is that maybe you just hit that point where it's increasingly difficult for you to be able to do your own banking, to pay your own bills, to manage your own finances. And if so, you can actually empower somebody else through a written document to have the authority to collect your income and pay your bills. And you can make that as expansive as you want. You can trigger it based on if it gets to a point where you're determined to be not competent, it would kick in then, or you can make it kick in immediately where you'd have sort of co-authority to manage your finances with the person who's power of attorney. In addition to that, it could spell out all of the provisions. You want them to have the ability to collect money and to pay out money, but whether or not you want them to give gifts to yourself, to themselves or not, is something that you have to make that decision. And you can even frame that, give gifts in amount not to exceed, $50 or $100 or whatever. So that basically gives somebody else the authority shared with you to be able to make those decisions. And then when you're no longer able to make them on your behalf. The medical power of attorney basically functions like we talked about with the guardian, where you're talking about physical care and who's going to make the decisions of, am I able to continue to live in my own home? And if so, with what assistance, what I need to have to continue to do that. And maybe I get to a point where I can't make that decision anymore, but I have somebody, I have a family member, I have, a clergyman, I have somebody that I trust and I've communicated my desires with, and I know that they'll honor those. And I would then give them the authority to make that decision. Absent either of those, then you end up in probate court because you haven't made those determinations. And then the court's responsible to make that decision basically without your input, and at least without the ultimate decision. You can still recommend people. Maybe you want not that daughter, but this other daughter. You can do that, but it's really still up to the court. You sort of forfeited your right to pick that person.
Wow, it sounds like we should all have that, those durable power of attorney forms, both the financial and medical. Is that safe to say?
I think that's true. I think one of the things that happens often is we kind of have this mindset of, well, I won't need to worry about that until I hit 70, 75, 80. And then tomorrow I'm in a car accident with a closed head injury. And that time for me to make that decision is ended. I'm not in a position to make that decision anymore, and the court's going to make it for me. So yes, I think there are also some caveats. I think you need to be very, very careful when you give somebody else control over your finances, because oftentimes we have cases where people have powers of attorney, have abused those documents to financially exploit vulnerable adults. So you have to be very careful about who you pick. And then you have to stay very actively involved in monitoring what they're doing with your money. And so that we don't have situations where we had a case we're prosecuting right now where the person who was picked as a power of attorney had taken over $100,000 from their grandmother. And they're going to go to prison when we get done, but it doesn't get the $100,000 back. And so yes, it's important to have those documents, but it's really important. And I think it's appropriate to seek legal advice to guide you through that decision-making process and to create a document that provides the most protection. Downloading one off the internet generally does not comply with Michigan law, and it also doesn't take those extra steps that will protect you.
Well, that sounds like sound advice we should all be following. Now, what should I do if I suspect financial exploitation of a vulnerable adult?
That's, again, a really good question. First of all, there's multiple places you can report that conduct. One is Adult Protective Services. If that person is residing in a nursing home, you can contact the Office of Attorney General of the Healthcare Fraud Division, and they have the jurisdiction to go into either foster care homes or licensed nursing homes. You can report it to local law enforcement, and we also have online reporting with the Office of Attorney General. Now, generally, we take the larger cases, and the smaller cases are referred to the county prosecutor.
What about if I suspect elder abuse or neglect?
Well, again, the first line of defense for elder abuse is Adult Protective Services. If you think somebody's either being physically abused or emotionally abused or neglected, contact Adult Protective Services. And then you can also contact law enforcement. Now, understand, if you contact Adult Protective Services and they believe it involves criminal conduct, they will notify law enforcement. If you contact law enforcement, they are a mandated reporter to Adult Protective Services. So either one of those would be appropriate to report to. And then those cases would end up being filed ultimately with the county prosecutor.
And I know, Scott, what helps me is I always have my no excuse for elder abuse pamphlet at an arm's length, because you went through all those different places to refer people. And I would suggest that the participants today get this pamphlet because it lays all out. If this, then that. It's a really, really helpful pamphlet, and people won't be surprised that they can find it at mi.gov/elder abuse. And they can also get that by emailing mi@elder MIAG, excuse me, MIAG@mi.gov. It helps us if you put no excuse in the subject line, but that's absolutely where you can get hard copies of this pamphlet. It details everything that Scott covered in terms of where to go, who to report things to. It's one of the first things the Elder Abuse Task Force put out, and it really is a good pamphlet. So we also have contact information for the task force. There's a phone number, 800-24-ABUSE. That's 22873. The website that we've mentioned many times, michigan.gov/elder abuse. You've heard me say mi.gov, that works too, but if you want to spell Michigan out, have at it. And then the email for our healthcare fraud division, hcf@mi.gov. So Scott, anything before we turn it back over to Kelly that you want to add or think that we maybe didn't cover or should cover in a little bit more detail? We have a few minutes left here.
Well, I think the key is that we have, and it really is humbling to see the broad support that this effort's received. And I meant that literally. We have not had one organization say they didn't want to be part of it. And we had a number of them contact us after they found out what was going on to see how can we help. I think they sense a lot. I know under this administration, it is a major priority of Attorney General Nessel. It's obviously a major priority for Chief Justice McCormick. And I think that effort is already starting to yield some significant changes. The legislative package that we're working on literally is a game changer. Some of these changes are not going to happen overnight. They're not going to happen, easily because it didn't get this way overnight. And but I've told people from day one on the task force that this effort is so important because just in dealing with the elder population in Michigan by 2030, it will be 20% of our population, which will be over 2 million people. And understanding that demographic, it is not because people are flocking to retire to Michigan because the winters are so fantastic. It is because they lived here. They lived here 40, 50, 60, 70 years. And so as a result of that, these are the folks who built the streets, who built the factories, who built the schools, who built the towns. And as a result of that, now in those older years, what they need is for us to step up and at least give them a safe environment to live out the rest of their lives. I don't think that's unreasonable. And I think as a result of that, it really requires a lot of really talented people being willing to step out and to work really, really hard. As I said, that schedule, and we've been on it for a year and a half, is the most aggressive of any task force I've ever seen. It includes more resources from our office than I've ever seen, and I've been there since 2003. And it's people that, I have private practitioners who set out time from their law practice that's not billable to work on this. Literally it's across the board. But I think the goal is at the end of the day, we're going to change the trajectory in Michigan of how we treat older and vulnerable adults in a way that will impact the lives of literally hundreds of thousands of people. And at the end of the day, isn't that what we're here for? And we have the positions that we have to try to make life better and to fight for those people who can't fight for themselves. That's what we took an oath to do. That's what the Attorney General took an oath to do. You did. Again, the justices from the Supreme Court did. And to see them step up and turn that from a promise to a commitment, and to do that week after week after week after week, for me is very inspiring, and it's also very humbling. There's a movie called League of Their Own, which is a women's baseball team that was organized during World War II. But at one point, the one girl says she's going to quit, and because it just got too hard. And the coach responds, "It's supposed to be hard. If it weren't hard, everybody would do it. It's the hard that makes it great." Well, I'm telling you, that's exactly what we're working on. The stuff that we're doing is stuff that has continued to decline and that continued to deteriorate in our state over decades. Yes, it's hard turning that around and making changes. And at one point, it means we're gonna have to go to the legislature and see more resources committed to this fight. And maybe we leave 50 potholes unfilled and take care of people who can't provide for their own care. Well, if so, then those are hard decisions, but it's time that we make those. And so, again, I so appreciate the commitment of my boss and the other members of the task force, because it shows that at the end of the day, people really are willing to set aside whatever they're working on and to commit it to make other people's lives better. And that's a great group of people to be able to surround yourself with. So, thank you.
Yeah, I couldn't agree more, Scott. I've been with the office nearly 30 years, and this is the best group that I've been a part of. So on behalf of the, Attorney General's office and the Elder Abuse Task Force, ADA 30, congratulations. Thanks for making us a part of your series. We're humbled and we appreciate it. So I'm going to turn it back over to Kelly.
Thank you, Catherine and Scott, for joining us for today's session. We have greatly enjoyed listening to your passion and your expertise on this topic. It is greatly appreciated. And we would also like to thank Michigan's Elder Abuse Task Force for participating in the ADA 30 series. And finally, we just want to extend a special thanks to our ASL service providers today, Marilyn and Bethany. Thank you so much. Thank you for joining us. Today's session has ended. You can find information on additional ADA 30 sessions at www.michigan.gov/ADA 30. You can also share your story on social media by using the hashtags ADA 30 and MIADA 30. That's Michigan ADA 30. Again, thank you so much. We've greatly enjoyed having you, and we hope you have a good rest of your day.